Well, welcome everybody. Welcome to Rent Control 101. My name, as I said, is Amelia Platas. This is my colleague, Micah Michalski. We work for the Rent Control Board and the Public Information Department. And we hold these seminars a few times a year. And tomorrow we're having one for property owners and landlords. So if you're interested in that side of it, you're welcome to attend that as well. Let's see. Hello. Rent control or water?
Rent control.
Sign in, please.
And both this one and the landlord seminar will be online, hopefully early next week. So it depends on how long it takes to get it all together. But
Will there be a time to ask questions?
Yeah. Yeah, there will be. So today, what we're covering, it's basically an overview of rent control. Main things, what are the lawful rents? We'll talk about unlawful rent increases, amenities and maintenance, and rent decreases, as well as eviction protections. So just a little background, a little history. The rent control law was passed on April 10th, 1979. It was an amendment to the city charter. It was voted by the residents. And at the time, rents were rolled back to what they were a year prior. So those of you who live in your units and you moved in prior to January of 1999, your rents are based on what the tenant in your unit in April of 1978 was paying. And until the mid-90s, it didn't matter whether somebody vacated their unit or not. The rents basically remained the same. And then things changed, and we'll talk about that a little later. But so that's sort of a little bit of the history on that. The board established a governing body, which is separate from the city council. So we're kind of our own little separate little agency. We're of course are part of the city, but we answer to the Rent Control Board, which is an elected body of 5 commissioners. We don't answer to the city council the way the rest of the city departments do. We have several departments, obviously administration, public information, which is us, and we have 2 other colleagues that do the same thing. We answer phone calls, we're there at our public counter. We're open daily from 8 a.m. to 4:30 p.m. We do close for lunch for an hour from 12:30 to 1:30. And as you probably know, City Hall closes every other Friday. So if you ever want to come in on a Friday, give us a call first. But otherwise,
can we just come in now? We don't have to call?
You do not need an appointment. Unless you're filing a petition, things that take a bit more time, then we recommend that you make an appointment. But otherwise, you can come in. Yeah, we take walk-ins. Mm-hmm. Yeah, just don't come at lunch, 12:30 to 1:30, because you'll have to wait. We close at that time.
And you open what time?
We open at 8 a.m.
Oh, okay.
I think most of the handouts here have, and the cards the cards don't have it, but it's on our website, so you can always call. Then we have a legal department. The legal department is basically there to advise the board. They're not a public, they're not attorneys to advise the public. They are there to advise the board. And then we have a hearings department, and if any of you have ever filed a petition, the hearings department, they're hearing officers. They act essentially like judges in an administrative hearing. And if somebody files a petition either for a rent decrease or because they were overcharged, or there's other types of petitions, then the hearing officers would hear those cases. And so that's how our agency is made up. The units that are subject to rent control, it's about 27,000 units in the city. I believe it's, what are the numbers? There's roughly 27,000 units that are covered by rent control. They're the units that essentially existed at the time that the law was passed. So units built after April 10th of 1979 are generally not under rent control. There could be exceptions sometimes because of settlement agreements where somebody was allowed maybe to demolish a unit, and there could be replacement units that are under rent control, but for the most part, newer units will not be under rent control. Most single-family homes are also exempt from rent control. Again, there could be exceptions, but for the most part, single-family homes are not controlled. And then also owner-occupied properties, when they are small properties, 2 or 3 unit properties where the owner lives on the property, owners can apply for an exemption, and that exemption, if they qualify, will be in effect as long as they meet the requirements of living on the property and maintaining their ownership. So what we're going to go over today is basically what my boss likes to call the 4 legs of the rent control law. That's why we have a chair here. Basically, all rent increases during a tenancy are controlled. Remedies are provided in situations where excess rent is charged where maintenance is neglected. There are eviction protections. The reasons a tenancy may be terminated are limited. And then the physical removal or conversion of a controlled rental unit is also restricted. So those are the 4 primary things that the rent control law provides. There are some things that are landlord-tenant related, but are not specifically addressed by the rent control law. Hi there. Yeah. So while there may be other topics that are landlord-tenant related, we won't be discussing them because they are not part of the rent control law. So there's municipal code issues, there's state law issues. Unfortunately, we're not able to cover those or give you legal advice on those. And those things include things like the return of the security deposit, an owner's right to enter the unit. Oops, I'm behind my slides. There we go. Things like permanent relocation, short-term rentals, the smoking ordinance. Those are all landlord-tenant issues, but they're not addressed by the rent control law. So we're limited to what we have the authority to
But you have
enforce.
paperwork there that addresses tenant harassment and
Yes, and
eviction.
if you notice, it's from the city attorney's office, if you look at the heading on it. And I did bring those because a lot of people have asked about that, but it does say to contact the city attorney's office.
Yes.
Are you discussing this stuff with the owners tomorrow?
No.
The code, okay.
We're going to say the same thing to the owners, that these are things that are not
Because
addressed
you
by
did a couple of years ago, that's when you had the code person, right?
Yeah.
Right, there's a different seminar that we have.
It was like in the fall.
We have different ones, yes, and there's one, you're right, the one in the fall, we invite code. That's generally the maintenance seminar, and we have code come in, and they talk about that too. I think one year we had the county health department discuss what they cover.
And we've also co-hosted a seminar with city attorney's office where they were able to dig into some of those questions as well.
Are you going to address roommate situations tonight? Because it was said.
Maybe at a high level, where the rent control law says that a tenant may replace a roommate on a one-for-one basis, that's something that we can talk about as an amenity.
Okay.
I don't know if we're going to be able to get into very deep or specific questions about roommate situations. Those may require you to call in and talk through that whole question.
Mm-hmm.
Yeah, this is meant to be a pretty high level discussion of rent control and kind of give you an idea of just an overview of it. That's why we're calling it 101.
Mm-hmm.
But we'll dig in a little bit where time permits and where we can. But we'll see where it goes.
Okay, I'm gonna pass it over to Mike.
So my turn now. We're going to talk about what is a lawful rent. So the maximum allowable rent, we call that the MAR, and then there's something called the maximum lawful rent, which is MLR. Doesn't quite have the same ring to it. But the maximum allowable rent, you think of that as the base rent. So that was whatever the base rent was when a unit first came under rent control. It's what the tenant was paying April 10th of 1978. And then that gets adjusted generally each year. We call it the general adjustment. That's usually some percentage or a cap. And then a landlord is able to add only two things to that. They're able to add the registration pass-through fee, which is the rent control fee. The landlords are able to pass through half of what they pay on a monthly basis to the tenants. And then in some cases, they are allowed to pass through surcharges from the property tax bill. This is only for tenants that moved in before March 1st of 2018, and only if the property has not been reassessed, so the taxes have gone up on it since that date also.
And that half is divided by all the units, right?
So each unit is charged, so the landlord gets charged per unit per year. They pay for the whole unit up front. So they pay $228 per unit per year currently. Half of that on a monthly basis ends up being $9.50. So assuming they have a tenant, they can recoup up to half of that throughout the course of the year. All right, so for pre-1999 tenants, we talked about this a little bit already. The MAR is based purely on that April 10th of 1978 rent, plus all of the subsequent general adjustments since that time. So it doesn't matter if somebody moved in the 60s or 70s or 80s, or if somebody moved in, my mom moved into her apartment in 95, right? So that's all, or 94, I don't remember. That's all based on that same original starting point. For tenancies that began after January 1st, on or after January 1st of 1999, that MAR is, it's a market rate, right? So whatever the landlord and the tenant agreed to for that initial rent charge during the initial lease term, that is the base rent for that unit, and that is what's controlled. So that amount is what the general adjustment is applied to each year. When that unit becomes vacant, and it has to be what we call a qualifying vacancy, so there are certain circumstances that don't trigger this, but for the most part, when that unit becomes vacant, the landlord's free to set a new market rate, and whatever that new tenant and that landlord agree to is a fair amount, that's what the new rent is, and then that's what's adjusted each year. All right, so if you wanted to check a unit's MAR, we have a feature on our website, look up a rent. So if you were to go to that santamonica.gov/rent control page, you were to click on more rent control topics, it'll take you to our second page, which is rent control in Santa Monica. And you'll see that colorful tile as you scroll down, it says look up a rent. And then that'll take you to our maximum allowable rent database. There is a place near the bottom, as you scroll down, it can be a little bit finicky, so you have to really follow the pattern that's called out on there on how to enter the address, but you're just putting the numbers in the number box and the street name in the street name box. How are you for the rent control center?
Yes, I am.
Come on in, sign in.
Sign in and just find a seat.
Thank you.
So the caveat with that is if the unit is vacant, that MAR is going to get reset when a new tenant moves in. So this data is based on the last time the unit was registered. And if you don't see a tenancy date next to that unit, that means that tenancy began before January 1st of 1999.
So what we pay for rent is public record?
Yeah.
Yeah, I mean, there's no names attached to it or anything like that. And it is the maximum, so it's not necessarily what the landlord is charging. They could be charging less than that, but it's whatever that rent ceiling is for that
But the
unit.
apartment number is listed there.
The apartment number is listed there,
In
yeah.
fact, if you do that, it pulls up the whole building.
Yeah.
So you'll see it's
No privacy, huh?
it's public information.
And Micah, does it matter on that MAR, like if they have how many bedrooms is wrong or how many bathrooms is wrong? Does that matter?
No, we only use that as a guideline. That is not the official record of how many bedrooms there are. If we got to something like we talk about permanent relocation and permanent relocation being calculated based on the number of bedrooms. This is not the record that would be used for that. So It generally is more of a guideline to help us make sure that the landlord is registering the unit that they think that they're registering. And it is admittedly not perfect because it's a lot of data that's been entered over many years. So we talked a little bit about the registration fee already, got a preview of this. The current fee is $228 per unit per year. The owner has to pay that by August 1st of each year, and it covers July through June. So that's the time period that payment actually covers. They need to pay it by August 1st for it to not be considered late. And as long as they don't pay it late, they are eligible to pass through 50% of that registration fee to the tenants, and that's that $9.50 per month fee that you might see on the notice of change in terms of tenancy.
When was the last time the 228 went up, and when can we expect it to go up?
About 2 years ago.
Yeah, I think it was in 21 or 22.
Yeah. And
How often
then
does it go up?
what's that?
How often does it go up?
I think roughly every 5 or 6 years.
Yeah.
Thank you.
You had a question?
What if the number of units in the building is wrong on the MAR?
I would be interested to know that.
Okay.
So I don't know, I can't answer specifically what that means, but it would be interesting to find out, especially if it's too low, if there are additional units in there. Sometimes that could mean that there are units in there that are not subject to rent control. For example, if a building was torn down and it was given a removal permit and they said we're going to replace the same number of units, same number of rent control units and build a bigger building, there may be 15 units that are subject to rent control and another 35 that are market rate. That's one of the rare cases where a building that was built after 1979 would still have rent controlled units in it. So that's just an example.
Yeah.
But we'd have to look at it on a case by case basis. All right, the last part of the maximum lawful rent are the allowable surcharges. And again, this only applies to tenancies that started before March 1st of 2018. There was a law change at that time. And there are certain parts on a property tax bill, and that'll be on the next slide, they're called voted indebtedness. So these are things that the residents of Santa Monica, I believe it was just by a simple majority, voted to add to the property taxes. Yeah, it's mostly school district stuff. There's like some stormwater recovery, something for the community colleges or community college. So those things, because they were passed by the voters of Santa Monica, part of that was that a piece of that was able to be passed on to the tenants. That is capped at either 4% of the MAR or $35, whichever is less. We're running out of tenants that 4% of the MAR is less than $35, but there are still a few of them out there from way back when. So if the property, and then again, this is important, if your property sells, it gets reassessed by the county, the taxes go up, that new owner loses this ability to pass through those surcharges. So
only for 2018 and beyond?
any building that was sold
After that date,
after that date.
at March 2018.
Right, but what about the tenants that are there since 99? Do
If
they
the
have to
property
pay-
was reassessed, no, then you
Yeah.
don't pay that either.
If the property was reassessed, that new landlord loses that ability to pass through those surcharges.
And you would assume if a new person takes over from one building, a new owner comes in, that property has to be reassessed, correct?
Yeah, you may want to check with the county. You can check on the county when the last time your address was reassessed, and if that date was after March 1st of 2018. Generally, we ask that you first let your landlord know that you've noticed that they're charging a fee that they're not supposed to. We'll talk about it briefly in a little bit, but if they have been charging you that amount and they continue to charge that amount, we have a process called an excess rent complaint that can help recoup some of those extra charges that were incorrectly charged.
That building's been sold recently and a few times. Can you look it up for 1 second?
Sure.
Sure of it. So I'm when I get home.
It's actually on the notice of increase that you get in September. It's kind of in bold right there. It actually says that it only applies to tenants who moved in after March 1 of 2018. or for properties, it says something about
Yeah,
the
I think we have-
reassessment too.
I
I
didn't
think
know
we have-
anything about the building consulting, about all the other stuff, so
Yeah.
this is, just something I wanna check.
Yeah.
It's, my building's managed by a very reputable company, so I'd be surprised, but I've been surprised, so I'm
Yeah.
gonna check.
I'm a little confused.
Sure.
So if we're in there since 95, 99, okay, and a new owner, a person buys the building,
Yeah.
he's gutting the old apartments, renovating, doing the whole thing. At that point, he has to have the building assessed for taxes, correct?
Correct.
So if he has that building assessed, whether it be higher or lower,
Mhm.
regardless,
Yep.
we don't have to pay that?
Correct.
The
How does he get away
reassessment,
with it? No, I
Well-
mean, like, the whole building, I've been paying it for years.
So we need to check and make sure that the property was actually reassessed with the county. But
after 2018,
give us a
it has to
call.
be after
Yeah.
that date.
Okay,
give us a call and we can talk through that specific situation, and you may need to file an excess rent complaint.
do we find out through you whether or not it's been
We might be
reassessed?
able to tell because owners have to register their ownership with us. So we should have a record of whether it's a new owner. There's rare cases where it's a transfer in title that doesn't result in a reassessment, but most of the time, so I'm not gonna say, every case, but most of the time, if it's a bona fide sale, because the value has gone up, it gets reassessed. It's not because they do work on the property, it's just simply because, the guy who bought it in 1968 and he sells it in in 2000 and whatever, it's just the value has gone up, and so it's just automatically reassessed.
So
And
because
it hasn't gone up, but it's just reassessed. The word is reassessed.
Reassessed,
It doesn't
and-
matter if it went up or went down.
Right, and you can check on the LA County Assessor's portal, and that lists all of the dates where a property was reassessed.
I always find that it's helpful to understand the reasoning behind this, and maybe, I'm sorry,
No,
getting
go
into
ahead.
this, but, because I worked here a long time ago, and prior to having these like market rate tenancies and all of that, owners really were, especially if they owned the property for a long time, the rents were low. And when tenants voted to pass bond measures, owners were the ones paying them, even though the tenants were the ones benefiting from them, and yet they couldn't increase the rents to cover that.
Right.
And so that was the reasoning for allowing some of these, like the school bonds, the ones that really it's the local people who benefited from them. But the idea is that if somebody is buying a property, they know going in what they're taking on. So unlike the owner who already owned the property and then this got voted in and they really had no control over it, somebody who comes in and buys the property, you know what you're getting into, so you don't get to pass this on anymore. You come in with your eyes open.
And the way that they're running their business, they should be accounting for the cost of the property taxes
Exactly.
in what they need
Yeah.
to recoup per unit. You have a question?
Yes, I was just wondering, how common it is that, the excess rent complaint is going in for this reason, and are there other reasons that one would apply for an excess rent complaint?
Yeah, anytime a landlord charges more rent than they're supposed to, that would be a time that somebody would start the excess rent
Is this happening
process.
quite a bit with this assessment
I mean, we
situation?
see,
It happens, it's not,
yeah,
I think most of the time it gets resolved. It does happen that owners, they buy the property and they just continue to charge what the last owner was charging. Most of the time, if they're put on notice and they're told, they'll give it back or they'll credit you.
Yeah.
And so a complaint isn't filed with us because it gets taken care of. But occasionally, we've had
Yeah.
some that get filed.
and I don't want to get too much in the weeds on the excess rent
Yeah.
complaints right now, because we do have some slides on that a little bit later. So, if you are being charged the surcharges from the property tax bill, the owner must provide you a copy of the property tax bill. It looks similar to this. This is an older one. We didn't get a screenshot of the most recent one. But it is basically the same every year. The ones that we've marked here in bold, those are the ones that they can pass through. So, and again, these slides will be up online if you want to look at this more
If
closely.
they don't provide it, what
That is
recourse?
another reason that you may file an excess rent complaint, because they're not in compliance. All right, so the general adjustment to the MAR, we call it the GA, and the purpose of this is to try to provide property owners with a fair return. One of the stated goals in the charter is to provide landlords with a fair return and no more for their rental properties. So the general adjustment is based on a 75% change in the consumer pricing index for the Los Angeles area for the 12-month period ending in March. So every year we get that data, and then Measure RC that happened not too long ago, that capped that maximum at 3%. So even if we have another year with a 6% or 8% inflation rate, 75% of that would be more than 3%, but the voters put in place a cap on that of 3%. So that's the most a general adjustment can be going forward. And then if the unit qualifies for the general adjustment and proper notice is given, a GA can be implemented as early as September 1st of each year. It could be implemented anytime after that, even several years later. If an owner did not implement a previous general adjustment, it doesn't expire. They can't go back and collect GAs that they missed. They can't ask you for more money going back, but they can implement as many GAs as they've missed going forward with proper notice.
Regarding RC, we have some tenants in our building that I know that the property manager, because I had to come and talk to you guys directly to get the decrease. They didn't do it for everybody. Like, they're just sitting there waiting for people to actually complain. So how long do the tenants have to ask for the refund?
36 months.
That's
36 weeks, did you
Months.
say?
36 months.
Which is 3 years.
3 years.
3 years, basically.
All right, so the notice of rent increase, the notice of change in terms of tenancy, as it's called, this is the long form, and it includes, starting up at the top, on the right-hand side, you'll see numbers 1, 2, 3, and 4. Okay, 1 is your old MAR. Now that's not necessarily what you were paying, that's what your old rent ceiling was. Okay, and then line 2 is what the general adjustment was. Now that's either going to be a percentage amount or it may be a cap. We don't know yet if the board is going to set a cap for this year, so it may just be a 3% change. The new MAR is those two numbers added together. Okay, and then line 4 is that rent control fee pass through. That's part of that maximum lawful rent we were just talking about. And then for C, surcharges from the property tax bill, you'll see it says there, do not include if tenancy began or property was reassessed on or after 3/1 of 18. Right? If they can include it, this is where they would fill out that grid. It gives the full amount from the property tax bill divided by the number of units on the property. That gives them the annual per unit amount divided by 12, gives them the monthly amount. They have to add that up. There's also a 5G there, which is multiply line 3, the new MAR, by 4%. That's to see if that 4% cap applies or not. In most cases, it won't, because I think that rent needs to be like 6, I can't do the math in my head, 6 something.
Pretty low.
Yeah. I thought I had it, and then now I'm not confident. But and then either of those numbers, if either of them are less than 35, that's what goes in that next box, that line 5. Otherwise, 35 goes in that number because they can't charge more than that. And then D, new maximum lawful rent, that's really what you're looking for here. That should be your total of 3, 4, and 5. Those are those 3 pieces of the maximum lawful rent that we were talking about before. The new MAR, the surcharges from the property tax bill, and the rent control pass-through fee. And I mixed that order up. Sorry about that. All right. They should, they're supposed to sign it and date it, and this needs to be given to you at least 30 days ahead of an increase to your rent, a change to your rent. It can be more than that. And then the landlord can prorate a month. So that is something that gets a little bit confusing. The math can get a little bit tricky, but if they were a little late getting the notice out, and they don't say it'll start October 1st, for example, it is possible that they're prorating it. If you're not sure, you should ask for clarification from your landlord to see what their intention is when you get the notice if you got it late. Any questions on that form?
So the A is like, I want to know, just like this year we pay $1,000. So that means A is at $1,000?
It's not necessarily what you pay, because what you're paying may include the surcharges from the property tax bill and the rent control fee. So this is just your MAR, your maximum allowable rent, before any surcharges from the property
No,
tax.
I just talk about the column A.
Yeah.
The number.
It's not necessarily $1,000 if you're paying $1,000. It might be a little bit less than that, or if your landlord is behind on general adjustments, it might be more than that.
So if you're paying $1,000
Right now.
and that $1,000 includes the rent control fee, which is $950, and some property taxes, then what goes on line 1 or A is going to be less than 1,000 because they can't calculate the increase on the surcharges. The increase is only calculated on the pure rent portion, not the extra taxes.
Okay.
I don't wanna jinx us. We haven't had an increase since the RC. So if I heard you correctly, when they do an increase, you said it's gonna be you guys still up the MAR every year. So it's, okay.
That rent
So-
ceiling continues to get
Right.
inflated whether or not the landlord implements the
So
increase or not.
maybe it behooves our building to actually call you to make sure it's the right MAR?
I-
Or do you want us to check the website?
So that time of year, it can be a little bit challenging to get us on the phone for an extended period of time. So if you can do a little bit of the initial research and then I think that would be great. If not, there's only 4 of us right now, so
We're hiring
Yeah.
2 more, but that could take a while.
it'll take a little while. Our
Our
training
training is very intense
Yeah.
because there's so much to know that it takes a couple of months before we can set them loose.
and email is always good too, because we can kind of reply to emails on downtime and get stuff out within a day, most of the time, a business day. So
But we have 30 days from when they give it
Yeah.
to us anyway.
Yeah.
So we're on top of it.
And remember that we send out that summer mailing
Well, that's what
that has,
that has the number on it.
Yeah.
yeah.
That's impressive.
Yeah.
it's a lot of
It's about
automation.
everybody's, I know, but still, I'm just like, oh, it's got my name and my number and like, the amount's right.
It shouldn't have your name.
I
But
don't know.
It just
Yeah.
said resident, but
Yeah.
your
My
address
address was
is-
on it, my
yeah.
neighbor's,
Yeah.
it was labeled to me, or, my mailing label.
yeah,
Yeah.
we've had some years to figure it out and iron
Yeah.
out those
Right.
kinks. So
Makes
it's
me grateful that it's Santa Monica and that's where I live.
yeah. Thank you. So there are some two of the fees or surcharges can be waived for people with low income seniors and low income disabled. Senior in this context is 62 or older. If you meet certain income requirements, you can get the $9.50 waived. And that actually waives the full $228 for your unit for the landlord. So it's not even like the landlord pays half. Like they get a little benefit from you applying for that too. And then the Clean Beaches and Ocean Parcel Tax waiver. There's a Clean Beaches and Oceans Parcel Tax surcharge waiver exists as well. That one's pretty small typically for most buildings. That amount of tax, but in this economy, any little bit helps. So if you qualify for that, if you have a low enough income, and more information about that's available on our website or in our office if you want to see where those brackets are, and they're typically updated every July. All right, I know we've been kind of taking questions as we've gone, but any other burning questions from this first section here? We only got an hour left, so All right. So unlawful rent increases. So we just talked about what's a lawful increase. So what are unlawful ones? Yeah, that was not the slide I was expecting off the top of my head. But all right. So additional amenities can be added by mutual agreement only, and there's a little bit of a difference here also for pre-99 tenants and post-99 tenants because this is part of that law change. So Charging for additional amenities without a proper agreement may constitute the collection of excess rent. That's one of those situations where somebody might file an excess rent complaint. With pre-99 tenants, this needs to be done with a separate agreement. So if you wanted to add parking or storage or a pet or something like that, it's a completely separate agreement. It's not rolled into your MAR. It's not part of your base rent. That additional agreement can be canceled by either party at any time, and canceling that agreement is not a just cause for eviction. I think more of that is on the next slide, actually. I'm getting ahead of myself. Yeah, so it must contain terms that are comparable to those of similar arrangements in the unregulated market. So it's a free market agreement kind of a thing. Yeah, and so if you missed your payment on your parking, they could take it away, but it's not a reason for eviction. They couldn't evict you from your whole apartment just because you didn't meet your separate agreement.
Can you repeat that, please?
So the breach of a separate agreement is not a just cause for eviction because it's a separate contract. It's not a contract that's related to your housing. And this is only for pre-99 tenants. So this is only for tenants that moved into their particular unit before January 1st of 1999. For tenants that moved in post-99, you're limited only to 3 types of additional amenities that can be added. One is parking or a garage, one is storage, and one is the right to have a pet. Again, these must be the result of an arm's length negotiation with no pressure on the tenant to accept. You have to be able to accept or not at your choice. And the amount paid for the amenity must be comparable to lawful arrangements in the unregulated market. An owner must then register that initial amount charged for the amenity with the board. And this is that area where it's different. This gets rolled into your MAR. So this becomes part of your apartment and part of your base rent. And that also means that the amount that is getting adjusted generally each year is higher. So a 3% increase on something that was, for example, $1,800 but is now $2,000. Now we're seeing a bigger total increase on that. All right. Additional.
Go over removal of amenities?
We will get, yeah.
Thank you.
So for additional occupants, there's no provision in the rent control law that allows an owner to charge additional fees simply for having an additional occupant. A tenant's right to sublet their unit or have guests is usually controlled by the terms of their rental agreement. In violations of the rental agreement, they could be grounds for eviction.
If you don't have an agreement, if you don't have a rental agreement,
it would be very hard to enforce something that doesn't exist.
so I could sublet my unit.
I don't want to commit to that statement one way or another because that would be legal advice, but it would be very difficult to enforce an agreement that doesn't exist.
Interesting, thank you.
What about if it's a verbal agreement and you've been living there for a year?
It would be, it would be up to a judge to determine the understanding of the verbal agreement at the time and if that verbal agreement was breached and if there was sufficient evidence to show that the verbal agreement was breached.
So there's a gentleman in my apartment who's an elderly gentleman. He got married and the owner refuses to put the wife on the lease.
He does not have to put the wife on the
That's
lease.
different than allowing her to be there.
But she can be there.
Absolutely.
And she can be there because she's the wife,
Yeah,
not necessarily because the number of occupants.
but if he passes, it won't go to her.
So if she lives there for at least a year,
Oh, yeah.
she has the right to continue to live in the apartment. However, because of state law, the landlord has the right to reset the rent because that tenant has permanently vacated the unit. So,
Yeah.
Odds are the landlord will probably raise the rent enough that it's probably not worth staying there. But,
Unless the new law gets passed.
right, so, but we don't know.
And so, because it's whoever's the lease names up.
Mhm.
Okay, because
The named tenant, yeah.
our lease has my husband and I,
Mhm.
but it has it for 4 people, and they have named our children on it.
Mhm.
But they're not on the lease line, but they are listed in the agreement as being tenants there. And so that's what we always
So-
wonder, because they're adult children, one is still with us,
Depending on how long they've lived there,
20 years.
yeah, so, it may be something that needs to be argued in court and how the contract is written. It's really hard to say on a case-by-case basis what a judge will or will not accept, and if that constitutes, usually if the person's named on the lease and they've lived there and they haven't moved away for anything other than like school or anything, often that is fine. Often that's enough that the landlord has to establish a tenant relationship with them, and if, for example, they needed to start paying the rent because they're listed on that lease, odds are they probably would need to, I have to speak kind of
No, I understand. No, I'm,
tentatively about this, but
no, I understand. That's what I'm asking.
odds are that your child probably could start paying the rent because they're named on the lease, and then that would firmly establish a landlord-tenant relationship with them, which would secure that rent.
Because that goes to, because I'd asked you guys before you at the end that you had said that, say my husband dies, you said you can still get a fourth person in.
Yeah.
And so my question is, so I get a fourth person in, and maybe it's Lloyd what they're asking too, is how does that person coming in feel secure?
They're not.
They're not. It's not the same as your children that were born in the unit or were minors. Because typically minors, most rental agreements don't name minors, but that doesn't mean they didn't have the right to be there. Right. So that's different from bringing in a replacement roommate.
So say I grow old in this apartment, it's been 20 years, and I get a tenant. If I pass, the owner could pick out the person who.
Yeah. So a subtenant.
A subtenant.
A subtenant holding at the end of an agreement, because you're no longer party to the agreement anymore. That is one of the just causes for eviction.
Okay.
So a subtenant
And then authorized subtenant, because if they're authorized, exactly, because if they're authorized.
So if I have a domestic partnership that's properly registered, they can't kick out my partner or raise the rent.
So if you were to vacate the unit through death or incapacitation or otherwise, and your partner remained, but your partner is not named on the lease, they would have eviction protections, but they would not have rent protections.
What if I don't have a lease?
Then it goes to court. That's a lawyer question, yeah.
So does it behoove us to ask to get our kids' names put on the lease, or does that open it up to having the rent redone?
No, that would not, because there was no qualifying vacancy to increase the rent. So they may say no, and they could.
Because I know there was another mother in our unit that when the new owners came in and during the 08 and all the bank stuff, she got a new lease and she put her son on even though he was only 12.
Yeah.
And so that's why I was wondering.
What if her kids started paying the rent?
Well, that would be something that would establish a landlord-tenant relationship.
Yeah,
for a year and see if they notice.
That's what I was thinking too. Yeah.
In the back.
Is this the time to talk about smoking?
No.
No.
Not yet.
Just the date?
The date?
The date at which, if you were a smoker and you rented,
Um,
and then there was a law that got passed, no smoking.
December 2012.
yeah, December 2012. No, I think we touch on that later in the presentation, but
But it's a city ordinance.
it's not a rent control ordinance.
That's a city attorney's office thing.
But if you would be doing anything about it or advise?
We do not have a remedy for smoking. The potential remedy can be advised by the city attorney's office, but it's a civil remedy. It's not a cause for eviction.
They're gonna tell you go to small claims court.
Yep, that's what the remedy is. Yep. Yes.
Yes, my nephew moved in when he was a child, now an adult. I didn't think about putting him, or even asking about putting him on the lease, but I've been thinking about it, and I wonder if it's a question even worth answering. I mean, he's 30, he's been living in the apartment since he was 11. I think it would be up to the landlord, but is it a question even worth asking? I'm wondering.
Yeah, I mean, the landlord could say no.
Yeah.
And if he's moved in, since he moved in after 1/1/96, I think the only way to protect his rent for the future would be if he was added to the lease.
Yes.
So it's likely that they would say no.
Right.
Because they wouldn't want to do that.
That's what I was thinking, yeah.
Can you speak to, I don't know if this is the right time, but can you speak to if, like, you were talking about if you leased your apartment and it's in your agreement to not do it, it's, you know, that's grounds. But is there like what if you have somebody like stay in your house while you're out of town kind of thing? Is that
So it really depends on the lease and how the lease is worded, and then how much motivation does the landlord have to try to enforce that lease. So, you know, they may be looking for any reason to try to go to court on something, or they may not think that it is worth the time or effort or energy to do that. So, you know,
Do you have copies of every rental unit's lease?
No.
Because I have my original stuff from 2001 and it has your stamp on it. Because we had argued with them about a parking, they tried to take a parking away, and we have the stamp of City of Santa Monica, 2 spots. So, but you guys don't
Are
have
you in a
copies.
Torca unit?
No, I
Oh,
don't think so.
okay. I was just wondering.
It's a 20-unit building.
Can I have a question?
sure.
Maybe not related. Just say like if when I rent a unit and the first, landlord, before they sold the building, they just sold the stock, that's it. But like I lost the contract, so now it's the second one coming, after they sold the building. So like, do the rent controls have the copy of my rent, or I have to ask? How I ask, like, because ask the first one,
You don't have your original contract, is that what it is?
yeah, I lost it.
We don't usually have copies. Occasionally, it happens to be in the file. Like if you had a petition or something, or a hearing, or somehow it ended up with us, we might have it, but it's rare.
Very rare.
It's very rare. Owners, I believe under state law, if they have a copy, you're supposed to ask them, and I think they have 2 weeks to give it to you if they have a copy or something, but, they may not
Even
have
though
it.
they a new one,
Yeah, I mean, it's supposed to get passed from the old owner to the new owner. It doesn't always happen though. But if they have a copy, they're required to, if you formally ask for it, they're required to give it to you. But if nobody has it, then,
It's the kind of thing that may come up in discovery in court. Like if you requested it and you put in writing your request and they didn't give it to you, and then all of a sudden they show up in court and present it as evidence to evict you, you have this evidence that you requested it. Right?
What
that's why I
type of
always put
document
things
we're
in
talking?
writing.
I'm sorry.
What type of document are we talking?
A lease.
Can you just quickly just tell me how many units necessitates having a manager? How many apartments in the building?
16.
Yeah.
Is it 16 or
Yes,
15?
because we're,
No, it's 16.
16?
Yeah,
Okay,
it's state
thanks.
law.
yeah, we're fighting.
All right, utility costs. That's another kind of a hot button issue. Some landlords were throwing in utility costs as part of their, as part of the rent, as a way to get more people in, or a unit wasn't separately metered, as is often the case with water. It's a master meter rather than individually metered units. If a lease must declare a fixed amount for a tenant to be paying for their utilities, if the payment is going directly to the landlord, it can't fluctuate, and they can't use one thing that a lot of management companies that work in multiple cities have been trying to implement is something called a ratio utility billing system, or RUBS. That is not something that is lawful in Santa Monica. All right, so tenant not in occupancy. So rent controlled units are supposed to be used as the address of usual return for tenants. If an owner believes that a tenant no longer permanently resides in the unit, he or she may file a petition with the board to raise the rent to a comparable market rate rental. And a decision in favor of the owner is not a reason for eviction. It's not just cause to terminate the tenancy, but it can result in a large increase to the rent. So, if somebody buys a house somewhere else and they want to keep, I always say this wrong, pied de terre. I didn't take French. But that's a reason that a landlord could be eligible to raise their rent, because they're not using that as their primary residence or place of usual return. Conversely, if they're just away for an extended period of time, like for work or to care for a sick family member or something like that, and their intention is to continue to return to that unit as their primary residence, that is a case where this tenant not in occupancy petition would not go in the favor of the owner. So it really depends on the evidence presented on a case-by-case basis of what is the primary use of this unit, what's the intent of the use of this unit, and can the tenant show that this really is where they intend to be, they just are taken away for some extenuating circumstance.
Is there a time period, like if you do?
There's not a
6
set
months
time.
gone?
Yeah, there's not a set time period. We get asked that by tenants and landlords a lot. Like, if the tenant's not there for 6 months and a day, does that count? But there have been examples of people who, especially during COVID, during the pandemic, flew back east to be with their parents, right? And they were there for a year, right? But their intention was to return to Santa Monica, have this be their place of usual return. They just, because they were caring for parents or other family members or traveling nurse or whatever the case may be, weren't able to be in their unit for a set period of time. So this could actually be a much shorter period of time than 6 months. If somebody buys a house in Palm Springs and gets a tax credit as that being their primary residence, it's pretty obvious this other place in Santa Monica is no longer their primary residence, right? So that could be a very short period of time. Or this could be something that, I haven't seen this guy in 2 years. I don't know what's going on, right? So we see the full spectrum of this.
Even though they're still paying rent.
Yep.
Yeah. So there's like two parts to it. It doesn't matter if you're paying for it, you still have to physically be in the location.
Well, you have to intend for it to be your place of usual return.
Right. So that can happen, it can happen with subletting. So where somebody, they moved out, basically, and they've sublet the unit. Maybe their rental agreement, they're one of these people who doesn't have a rental agreement, doesn't prohibit subletting. So they can't evict them for subletting, but they can, if they can prove that the tenant no longer lives there, that they have, their nephew living there now, or whatever. And then if this gets approved, then, they can keep the unit, but they're gonna be paying a higher rent. And so a lot of times they end up obviously not keeping the unit because the benefit is to have a low rent. So.
I think this is a perfect moment to kind of segue into if roommates move out and then the landlord doesn't let you bring new roommates and they said you have to pay the full amount by yourself, even though there are 3 rooms and they were roommates before.
So that'll come in when we talk about decrease petitions, because that is number of people living in a unit as a housing service.
Okay.
So a little bit about complaints for excess rent. So any of these things that we just touched on, if the landlord's trying to charge more rent, sorry, I'm not trying to throw something over there, I swear. If they try to charge these things and you pay the extra amount to try to avoid, the landlord giving you a pay or quit notice or anything like that, then you would be able to file what we call an excess rent complaint. That can be filed by the tenant, or if you have a subtenant could file that as well. If the tenant or the subtenant believes they have been or are being charged amounts that exceed what is allowed by the rent control law. The first step in this process, and this is relatively new, this was a change in the law recently, is the tenant must give a written demand to their landlord requesting a refund of that excess amount paid. The owner then has 30 days to respond to that to make it right. If after 30 days they have not made it right, then you're able to file the petition with our office. And if a rent control hearing examiner finds that the excess rent has been collected by the landlord, the tenant will be authorized to withhold rent until the amount of excess rent has been recovered. The rent control board only has the authority to award excess rent complaints back 36 months. And interest and penalties can be included in the amount of an award. If you wanted to go back a longer period of time, or if it's something that's not specifically captured by the rent control law, but you feel like you've been overcharged in a different way, then your remedy would likely be civil court or small claims court, depending on those dollar thresholds. Okay.
The thing with this small claims court, because I've been through it, is that the judges are not well versed, and normally you have to go by yourself because the amount that is maximum is $10,000. So it is in the best interest to be heard by your department, because I've been in small claims, and these judges are sometimes drunk. To tell you the truth, it's like they're not hearing. They're saying things that have not been said. They don't care because they think this is petty, because it's such a small amount, and they don't like to be there. Just to be honest, and that's what I've been told by other lawyers. Is that unfortunately they don't consider these claims serious. So, it's in the best interest of the tenants to be heard and by you.
Yeah, unless it's going to exceed that small claims court amount, that's a fair assessment, I think. And also, if I can get on a soapbox for a moment, this is why local elections really matter.
Yeah.
These are elected positions in most cases. So, you all that are here are probably among the more involved socially, but it's important that people participate in the system. Are there any other questions on this section about excess rent, unlawful charges for rent?
I filed one, and then it was returned to me because supposedly it didn't included everything, and in the process my landlord took me to court to evict me. This 36 months have not elapsed yet.
Once you are no longer in the unit, rent control no longer has the authority to control your rent, so we would not have a remedy for you to withhold rent.
But she was charging me excess, she was using everything under the book
So
to,
but at that point, once you're no longer in the unit, our remedy no longer applies. So that's where the court remedy, unfortunately, would be your only option.
I filed this when I was in the unit.
Right, but the remedy is to withhold rent. And
So once you are not in the unit,
you're not paying rent to them
dismiss it
anymore.
because you have.
Yes, but I paid rent during when I was in the unit.
Right, but the remedy, which is to get that money back, the only thing we can do is tell you, okay, you don't pay rent for 2 months, 3 months.
Uh-huh.
But that's not gonna work because you're not in the apartment anymore. So that's why we can't hear those cases.
Yeah.
Yeah.
Those-
Legal what?
You have to go through the legal system now.
yeah, unfortunately, yeah. Is it my turn now?
I don't know.
Is it still you?
I was just gonna keep going, but go ahead. Go
You're
ahead.
so good at this, you should keep going. He's got a very good speaking voice, so.
I'm getting a little dry mouth, so if you want to take a turn.
Yeah, actually, it is my turn, so, okay. So now we're gonna talk about amenities and maintenance and rent decreases. I know a lot of you have
If I
questions
keep going,
about
we'll
that.
never finish, so it's.
Okay. So rent control staff are frequently asked about maintenance of rental units. While various laws at the state and local level address this issue, we'll be focusing on how maintenance is addressed by the rent control law. So, the Santa Monica rent control law encourages property owners to make necessary repairs and continue the same level of housing services and amenities that were provided on the base rent date. So remember, the base rent date is either, that 1978 date for those of you before 1999, or for those of you who moved in after, starting in 99 or later, it's whatever amenities came with your unit when you moved in. So, amenities are housing services. These are some examples, parking, appliances, the right to have roommates. That's considered an amenity or a housing service. And, maintenance, these are some, again, examples of some of the maintenance conditions that owners are responsible for. So the remedy through rent control for either an amenity that's taken away or a housing service that's taken away, or for lack of, repairs or maintenance, is to file a petition for rent decrease. Now, most tenants who call us and we tell them this, they say, well, you know, I don't want my rent decreased, I just want them to, you know, change my carpet or fix, you know, the dishwasher, whatever. But the problem is that our law is, you know, it's narrow, right? We control the rent, so everything sort of revolves around controlling the rent. That's why our remedy for excess rent is, you know, to reduce your rent. So we don't have the authority to force the owner to make repairs or to give you back your parking spot. But since you're now paying the same rent, but you're getting less for it because things have deteriorated or they no longer, you know, you no longer have parking, that is the logic behind you being able to get a rent reduction. And you know, and the idea is for it to be an incentive for the owner to take care of the problem. And sometimes it works. You know, a lot of times it does work. Sometimes, you know, less so. But you know, that is the process. Some issues, if they're more serious, you know, you may consider calling code enforcement or the health department because there's other, you know, state laws that can be enforced. And the thing about the health department and code enforcement is that they actually do have enforcement power. So they can cite an owner if they actually find a code violation or a health and safety violation. And they, you know, if they come out to the property, they inspect, they will actually issue a citation and give the owner a certain period of time by which they have to correct that violation. And I suppose like everything else in government, it's not a quick process, but if the owner keeps putting it off long enough, it can be referred for prosecution to the city attorney's office, especially if it's a more serious violation.
It is the city attorney, San Martin?
Yes, yes, or if it's the health department, I don't know.
Maybe county?
Yeah, I'm not quite sure how that
What's the
works.
time span? Like,
What was that?
what's the time span? Like, you, let's say you call today and they don't respond to you, how long before you?
Oh, I don't know what code, I mean, I don't know. I know it has to be pretty serious for them to do
No,
that,
I'm
but
talking
in
about,
terms
let's
of,
say, you know, fixing a leak.
it depends on what it is. There's certain conditions, like if you have no heat in the winter, that can render your unit uninhabitable. And if a code officer comes out, you know, when it's cold, because it's not gonna happen in the summer, but say we're talking about heat. If you don't have heat in the winter, they'll usually ask you, you know, do you, I mean, I can issue a habitability, I don't know what they call it, but they basically make a determination that the unit is uninhabitable, and then the city's temporary relocation ordinance kicks in, and the owner has to put you up somewhere. So it, you know, if it's something like that, it might be worth calling one of these other agencies, because our process, which I'm gonna go into a little bit, you know, it's not a quick process. It's not for urgent situations. If you don't have hot water, if your plumbing is like, you know, overflowing, don't call us, because we're gonna tell you, you have to write, you know, you have to put your request in writing, give them 30 days and then call
That's
us
what I
back.
wanna know.
So so that, you know,
Right.
our process is for maintenance, you know, or for non-emergency situations. But for emergency situations, it would be code enforcement or the health department. Health department tends to be more, you know, if you have sewage or if you have like a serious insect infestation or something like that. Code, you know, it's more probably, you know, building codes, I guess, is more, you know, kind of think of it that way. But
And I have interacted with building code, that's why, unfortunately, I just made this sound of like, because I was at a rent control meeting, rent control board meeting, where they admitted that they operate in silos, so they're not communicating with each other. You know, so code enforcement is not communicating with rent control, and rent control is not. So when you call and you make these complaints, unfortunately, if a landlord has good relationship with people in the city and have people inside departments that help them, they don't send you anybody. I have a landlord that did a lot of work without permits, like eliminating and violating code of fire department because there's not a fire alarm in the laundry. I mean, the laundries were washing and dry, so, and they don't enforce it. You know, it's years and
So
years.
if it's fire specific, it's definitely something you want to call the fire department. They have actual inspectors for that,
Yeah.
and they don't have any friends.
Okay.
So they don't care if you're their brother, they'll give you a ticket.
Okay.
So if it is fire related and it is fire specific, I definitely highly recommend contacting fire in their non-emergency line.
Thank you.
Yeah, in the back.
Amelia, when you say it's accusation or something, I forgot the word. But like, just say like, if how long, like the attorney, city attorney will, go after them, because it just say like if they fix, but they fix year after year after year, and it happen again, so like how like it's interrupt your life a lot, so who you talk to, like the do the city attorney have the right to like flog them for the violation or something?
They do, but I can't speak to how they make those decisions.
Ah.
Every so often, we'll get, there'll be like an article in the paper about the city attorney's office, the city's taking a landlord to court and fining them and blah, blah, blah. I don't know how they make those determinations. You have to file a complaint with them, with the Consumer Protection Unit typically, to start, and you've got to do it in writing. They won't take anything seriously if it's not in writing, because they're attorneys, and attorneys, it's got to be in writing. So,
Okay.
And it's also important to remember, I think, that ongoing active litigation and ongoing active code enforcement actions are both private. They can't risk their investigation by having everything out and telling us every detail of it, because they don't know if we're accidentally going to say the wrong thing to the tenant, or if they're somebody's going to come in a public meeting and hear something, and it disrupts their investigation. So that's part of the justification of it being siloed. I know that I constantly have conversations with people in code enforcement about what can rent control do and what can't rent control do. And I know that with Daniel Mick, their new manager, they've been trying to get more proactive about that, which has been great. But they do a very specific thing with a very specific part of the law, and we do a very specific thing with another very specific part of the law. And there really isn't the overlap that necessarily, I think, people assume that there is.
I understand the rent control try to protect us. I understand that. But sometimes, because like when they violate a lot and they just interrupt your life, and like keep fixing over again year after year, then it's like it's not only affect you, maybe affect the new tenant or something like that, and we don't want that happen. So we want like someone have authority come after them and force the landlord or the maintenance team need to like stop it, how to fire them or whatever, punish them.
It depends very much on what the condition is too, and what the repetitive nature of that is. We've had people file decrease petitions because there's an ongoing plumbing issue, right? Like they'll fix it and it'll break, and they'll fix it and then it'll break. And the ongoing nature of that, and the fact that the root cause isn't getting solved, can get addressed in a rent decrease petition potentially, right? But other things may need a private attorney to address, or may need the city attorney's office to address. It depends on if we're talking about something that can be addressed locally or something that's state law. It really is something that has to be evaluated on a case-by-case basis, and we'll try to do our best to point you in the right direction, but we're not experts in state law. We're not experts in everything that code enforcement does or the city attorney's office does. So sometimes, honestly, it is just our best guess of who we think you should talk to about what you're facing in that moment.
If you start the process of an email to you guys, is it wise to CC the owner?
So, I'm sorry, I'm stepping
No,
over
it's okay.
your section here.
So you have to, the notice, if you're referring to the notice for the rent decrease petition, that notice has to go to the owner. You have to put the owner on notice. They need to be told, I want you to fix, replace my carpet and fix my broken cabinets. So you have to send that to them. You don't need to copy us. You send it to them, you keep a copy. It has to be in writing, and in writing, we have a form that you can use, and we encourage you to use our form, but you don't have to. But it just makes it easier if you end up filing, if you use our form. But otherwise, you can send an email or a regular paper letter, not a text, but it goes to the owner or the property manager. And then you sit tight for 30 days. Hopefully it gets resolved. But if it doesn't, on the 31st day, then you make an appointment with us to file the petition. And we'll need a copy of that notice that you gave the owner. But if you send us a copy of the notice beforehand, honestly, we don't do anything with it. There's nothing for us to do.
Yeah, there's no action for us to take at that point.
But with that, because I think I've asked this to Micah before, what's the code enforcement phone number, or what am I supposed to Google? Because we are a 20-unit building, we haven't had a property manager, and I understand that you guys are all about taking away, decreasing the rent.
You can file a decrease for no property manager.
Right, no, I know that. And so once they come back and they're gonna say no, and they're gonna say no to my carpets, who in code do I contact to say, I've got 20-year-old carpets. I know I've read the California thing, there's no actual year because carpet wears differently, but Dan, you guys say every year to me, 20 years is a long time.
That's a long time.
And so how do I get somebody to come out, or what do you?
So code is really gonna focus more on habitability issues.
Right.
So carpet's not really that's really not gonna be something that they're going to prioritize.
Unless your carpet has holes and is a danger to people falling or something, then, you know. I mean, it has tacks and things. It's typically not.
Okay, so then where do you step in if they come back again and say no, and we say we're tearing it up? Do you guys protect us for that?
Depends on what your lease says, and no, the protection doesn't come from rent control, because there may be a provision in your lease that says that you can't do any substantial modifications, and I don't quote me on the language, because it's different for different leases.
But that's pretty standard on most leases, so you have to be really careful about doing modifications, because we have seen tenants replace flooring and then get a notice from the owner saying, you have to change this because you're in violation of your rental agreement, put it back. Even though you can argue that what they did was an improvement, but if you're violating, and it can be a just cause for eviction.
Yeah, we did that back in 2008 with the previous owner, because our unit is I'm in a 3-bedroom and we're a 2-story. So we put wooden floors in at the bottom. But it's the upstairs that's just a hot mess. But,
so at some point, you could get written permission from them to do that. That would be outside of the scope of rent control, but having that written permission from them to do that would be a way to protect yourself.
okay, so here's my question though, because when you have your lease and everything when you've moved in is brand new, because they know they have to replace my oven too. They've had an oven sitting for 2 years in a garage from a different unit. I have a feeling they're gonna try giving us that one. Plus our hood is a mess. So how do you get things updated if they're gonna keep saying no, and I get you guys are gonna just keep decreasing the rent?
Well, so that's the motivation, right? So one thing to remember is there's no obligation from the landlord to upgrade anything, right? Because you both came in at a certain level, right? And for pre-99 tenants, that level is based on the 70s, right? So, avocado appliances would be fine.
No, but I'm an 01, so yeah.
Oh, okay. So that's the standard. So the 01 standard is for, in your case, what they need to maintain. So an older oven that is fully operational and clean may be enough to satisfy that. It would be up to a hearing officer. If you filed a decrease and you had a decrease granted, it would be up to a hearing officer to see if the work that they did fully or only partially restores that reduction in rent. The idea is after enough time, they would be better off just doing the work than collecting less rent. That may not be enough motivation for them, but we're limited. We can't give 100% rent decrease for a portion of your apartment that is your carpet. Right? But that's really, if there were no rent control, you would really have no remedy.
Right.
Your remedy would be to move, which nobody wants to do that. So
My questions are about filing decreases and.
So I have somebody waiting behind you, and then.
Following from this lady's question, so does the tenant then, does she have no remedy if she wants new carpets, landlord says no, she says, I'll do it myself, landlord says no, then she's stuck
Her
with
remedy
it.
is to file a decrease petition. You
That's
can
it.
reduce her
That's
rent,
it.
and that's it,
That's it.
and that's it.
Okay. And then
Okay, so I had a number of issues, put them all in writing, filed, they came in, they fixed everything. This was with owner number 3. I am now on owner number 4. And I knew this was the change, that's why I got it in with owner number 3. So this is December 2022. The flooring they put in is peeling, getting dangerous in my mind. Is it a new filing or, so it's a brand new filing?
that sounds like a brand new one,
That's
yeah.
right.
Okay, because I have
Especially because it
notified,
is a new owner.
because I have notified the management company a couple times and said, hey, we'll let you know, they haven't done anything about it. So here's the add-on to that. How many times a year can I file for a reduction? Because
So-
I thought it was once.
So it depends, I get to say that a lot. If you have an active petition, you cannot file on any existing issues until 6 months after you receive that decision for that active petition. If new issues come up, you can now send a new notice and you can file a new petition for those new issues that did not exist or were not reasonably known during this first petition.
Okay, so
But for 6
What-
months, but then 7 months.
6 months after the decision.
decision,
So it could be a year, if depending on how complex your petition is and how long it takes to get a hearing and a
Because
decision issued.
so here's what's going on with my building. We, a representative of the owner came in January and said, we're taking away amenities and we're creating 2 ADUs in the front and back, which is awful, but I have no control over that. So we're gonna use our laundry room, storage, and I've got 2 parking spaces, so, I had already called you guys, I was told that the minute I get my 30 days notice to file with you, because I may not like what they're offering me for my reduction in amenities. Is that separate from repairs to the apartment?
So if the repairs needed to happen when you sent this notice and you reasonably knew about those repairs needing to happen, it's likely that you would have to wait until this other one resolved.
Because here's the catch, once they start building the ADU in front, the ceiling of my garage is my kitchen floor.
Mm.
So if I think my floor is bad now, wait till they start banging around. So I don't know whether I should just, it feels to me like maybe I should sit this one out a little bit.
And
But
you may just want to wait, because your notice can be, it has to be at least 30 days old, but it needs to be less than 180 days old.
Sorry.
So as long as it's in that window, you can get multiple notices in and you can file on all of those notices at once.
Oh, that's interesting, because they told us, so a representative for the owner came through. Management knew nothing about this. And they said, we may start as early as 6 months from now. I think that's really ambitious permit-wise. Is there a way for me to check if they've gotten their permits?
There's a permit,
Yes.
yeah, go ahead.
But we're getting behind, and so if you wanna talk to us afterwards, yes, we
Okay.
can tell you.
I mean,
Alright.
that's really important, because all of this is me calendaring when
Yeah.
I'm gonna make these complaints, and also for, maybe, getting reduction in rent during construction, since it's really.
Which is a
close
different
to me.
process.
So
We're gonna
speaking,
talk about that.
speaking of construction-related decreases,
Yes.
That's it.
Yes. So, yes, we have the standard old school decrease petition for maintenance and when they take an amenity away. But in the last few years, we've had an increase in construction activity. So we now have a construction related rent decrease petition. It is still a decrease petition, but it's a very different type of petition. With the regular decrease, you have to give them the 30-day notice, lay out what you want them to fix, wait 30 days, and then you file, and it's pretty straightforward. The construction decrease petition is different. The paperwork is different. It's a much more involved petition because you have to do a lot of the kind of the legwork up front. So the first step in one of those petitions is to contact rent control. So if there is construction activity in your building, And there's always going to be some, some impact when there's construction. So it's really when it's substantial impacts that, and it's been going on for more than a couple of weeks, give us a call. And this is happening a lot with the ADUs, so we're getting a lot of these petitions in. But one of the differences with the construction petition is that unlike the decrease where you have to give that 30-day notice and then it's just all going forward, with the construction petition, we actually will take into account when the impacts began. But that's why it's really important for you to document everything from the start. So in order to file one of these petitions, let me backtrack a little. So a construction decrease may be granted when a unit is uninhabitable due to construction, or when your either your housing services or just your ability to occupy the unit are substantially impacted. So one of the things to keep in mind, though, if the work that they're doing is something, for example, like earthquake retrofitting, that is something that they are required to do. That is not, like a discretionary upgrade. So we will not grant a rent reduction for those impacts unless the work is being done in an unreasonable manner or they're taking an unreasonable amount of time to complete it. But for a lot of these other projects where they're renovating empty units, units as they vacate, or they're building ADUs, those are the kinds of situations where you might consider a construction decrease petition.
What's an ADU? I'm sorry.
It's an accessory dwelling unit.
Thank you.
Sorry,
Sorry, yeah, we just.
Questions? So for the construction-related rent decrease, it wasn't the owner who was doing the construction, it was another tenant, and we notified the owner. So the tenant decided to completely remodel his unit, and in the process, it was very loud. It took over a month, and he also was like shutting the water off within like a 5-minute notice.
Wow.
So would we then be able to hold the owner responsible if it was the tenant who was doing it, but the owner knew about it? Like, we told him afterward and he just didn't get involved in it.
My first question with that would be, did he have the correct permits? And if not, then I would let code enforcement, that's right in their wheelhouse. And then that also goes with, if they're shutting off water, that's another thing that code enforcement can issue them a citation and make their little remodel project really expensive. Typically, we do not have a way to go after a landlord for the behavior of another tenant. The law doesn't support us in that. But it's, I think that is something that maybe we would need to hear a little bit more about if it was still active, and let our hearings department and our lawyers talk about what they think that they can do and get back to you.
Thank you.
One thing I will say is for construction-related decreases, the work has to be happening at the time that you file. So if this is, something that was happening and they've stopped it and it's all done, it's too late to file. So the work has to be ongoing.
But if it's too late to file, can you have another?
We can sue them in court, but yeah.
Are these available to download the paperwork?
They're not. You have to contact one of us.
Yeah, the instructions are on the website, but because this petition is more involved, we prefer to be more involved in the process rather
Fantastic.
than just.
I appreciate the help.
Yeah.
You're gonna need it.
And it's very common for people to do multiple drafts and email them back and forth before they come in to actually submit this, because it needs a higher level of clarity than the regular petition.
And we look to see that, this is not a requirement, but typically, Micah and I happen to be the ones that handle construction petitions, and we check to see if there's permits or, and again, that's not a deal breaker, but that also helps us establish when we see that they
I
hold
appreciate the
permits.
help.
So would I call you to find out if the owner has pulled the right
Permit?
Permits and
No,
stuff?
but you would call code enforcement for that.
Code enforcement?
or building and safety.
Yeah.
Yeah. We can look at it at a high level, but if you want any information beyond, yes, there is some permit that exists, or
What if that blue notice that they put on the door? Is that,
I would still probably call and make sure that that's legit.
Yeah.
Call 311, call building and safety.
Yeah. We have limited access, you know, we can see that things have been filed, and there's certain permits that get routed to us for review, but outside of that, we're not, you know, those are the departments we use.
Any other questions on this section
Couple of quick questions.
Yeah.
So, I've lived in the same place for decades, so I have an old refrigerator that I have to defrost every week now. So, is that, when I leased the place, it was a furnished apartment. So my understanding from what I've seen here is that that would be covered under the amenities. So if I put in a request, they should replace it and not give me a fridge that tall, it should give me one that's
Yeah, it should be comparable.
When did you move in?
What?
When did you move in?
Oh, in 78.
Oh, 78.
Oh, so you were there in 78, so you know what you had, so that's great. 'Cause a
That
lot
makes
of
it
times,
easier.
yeah, it does,
Makes it a
because
lot
a lot of
easier.
times you've got somebody who moved in 90, but we're still going by 78 and nobody knows what was ready.
And my fridge has probably been there for 50 years.
Oh my
So,
goodness.
I mean, I'm just guessing, it was the original,
Yeah.
yeah. The other question, that's a
Yes.
yes, that
Yeah.
should be covered. The other question is, I'm living in a 60-unit apartment building with 3 stories, and the month of February, we had no elevator service for most of the month. Now, I looked online about how that may or may not be an amenity, and it looked like it could be as much as, you know, like 10% of your rent. So, it did get fixed, but the next time something like this happens, I'm just wondering, is that an issue to bring to you?
Yeah, it's challenging because something like an elevator usually is not left malfunctioning for more than 30 days.
Yeah, it wasn't quite that long, but like I say, it was a full 3 weeks.
Yeah.
And, you know, like I say, it's for a 3-story, 60-unit.
Our process can't start until the landlord has had
30
at
days.
least 30 days from when you've given the written
Okay,
notice.
that's good to know. Yeah.
So, on the one hand, I would say yes, give them a written notice about something that you may potentially want to file on. You don't have to file. If you file and they fix it, you can withdraw.
Sure.
But if you don't give them the written notice, now I wouldn't give them a written notice every day for every little thing, right? But, you know,
Are you
it-
on the 3rd floor?
I am, yeah.
Could
And, you
you
know,
file with like health or something as a senior?
well, yeah, I mean, I
You
I-
can call, who was it that?
code enforcement?
I'm just thinking that, you know,
Elevators.
if there were disabled residents, they would have been really in a bad way.
I
Yeah.
know, and we've had calls like that, but we still have that 30-day thing.
We have one.
Like health and uninhabitable maybe, like, I'm just thinking as you age, if you're still there and it's uninhabitable,
Cal
maybe
OSHA,
you
that's
can
what
get,
they
She's
do.
on site when she's
you
there.
can get,
State of California, you're supposed to be on site.
You know, I don't know because I know code told us that they refer people to Cal OSHA when it's on elevators, an elevator
really?
issue. So
Okay.
that would be, I think our local office for Cal OSHA is in Monrovia or something, but you can just Google it. Yeah, because I thought, I know, I referred people to code thinking, okay, you know, an elevator, but I believe they told us that they referred it out to Cal OSHA, so. But I agree with you, I know that that would be an issue. I've heard of situations like that in tall buildings where, you know, you have an elderly person who cannot go up and down the stairs and they're essentially kind of trapped in their unit until it gets fixed, so it's unfortunate we don't have a fast remedy for that. So.
If the construction doesn't, and you give the tenant's ability to use the bathroom or kitchen, or simply have access to the unit, would you still consider the request?
Yeah. You know, there are a number of different impacts that you could be facing. It could be noise, it could be dust, it could be vibrations, odors. It doesn't necessarily have to directly impact the habitability of the unit. I would keep in mind and keep your expectations in line that the less you are impacted, the less likely, the less the decrease is going to be. And then it's kind of up for you to weigh, do I want to do this paperwork for that because it's really not bothering me that much, or yes, this is pretty bad, even though it's not completely eliminating my ability to use the bathroom and cook and do all those things. Those are things that individuals have to weigh for themselves. But I think if there is construction activity happening, and it looks like it's going to happen for a while, it's probably better to err on the side of starting the process, because if you wait too long and the construction ends, then you can't file.
Yeah.
Is that,
Yes, thank you.
Yeah.
Can we touch about roommates?
we're getting to eviction protections now. I guess.
I just went because we have 16 minutes.
Right, so
14
I
minutes.
wanna make sure I cover this,
Yes.
because there's very little on roommates that the rent control law addresses, very little.
Yeah,
So
it really was
It's not,
just the,
it's kind of what he already.
And, you know,
just the decreased petition.
So-
This has been very helpful in terms, because when elections come, as you say, that elections, all the candidates that I heard for running for rent control, they're always talking about outside of the realms that they have authority to deal. So for the longest time, I thought, these people are gonna do something. And then when they get in office, they said, oh, we only deal with the money part, with the, we don't deal with this and this and that. I'm like, oh, but in your platform, you were talking about protecting rent.
And there are a lot of members of the rent control board that are very active with lobbying and like that AB 1620 that just passed about senior and disabled tenants being able to apply to move to a ground floor unit. That was partially written by one of our board members.
Yeah,
So
they do.
they
Well,
do
same
a lot of
rent.
that work. But
Do they move with the same rent?
yeah, they get
that's
to
the
keep their
whole
rent.
point. Yeah. It was a change, an amendment essentially, a change to the Costa-Hawkins law. So even though they're moving to a
Who did that,
new
Carolyn
unit-
Terrazas?
It was presented by Assemblyman Zubar. He was the author of it.
Right, but I know Anastasia
Anastasia
and
helped him
Carolyn,
write
I think,
that.
Yeah.
Carolyn
helped
too, I
them.
But it
Yeah,
was
they
brought
worked.
to the attention because people brought this to the
Right.
attention
Exactly.
of the rent control board, and that's the importance of this kind of collaboration and communication in these kind of sessions.
Yeah, no fault evictions.
Yeah. So evictions, that is another one of the strong protections in the rent control law. Even though, if an owner tries to evict a tenant, it goes through the courts, we're not the ones making the determination about the eviction. Having these eviction protections is really a very powerful thing, and you can ask somebody who doesn't live in a rent controlled jurisdiction what a difference having these protections makes. So basically, there are certain tenant fault evictions that are permitted, and then there's a couple that are no fault eviction where the tenant hasn't done anything wrong, but the landlord may have a right to evict them. So we have an eviction information sheet that's out there that maybe some of you picked up, and that has a good summary of what the no fault, the just causes for eviction are. But the more common ones would be things like not paying your rent, violating your rental agreement, causing a substantial nuisance or damage to your unit, refusing access to the unit can be a just cause for eviction. So, and then no fault evictions are typically, the most common one is probably when an owner evicts to move into the unit, and although that's limited, it is something that is permitted under certain circumstances.
I was recently told, and I was hoping to corroboration on this, it's first one in, first one out. So it's not like they could pick my unit because I pay the least amount of rent.
It depends on the makeup of the property. So if it was a 3-unit property with a 3-bedroom, a 2-bedroom, and a 1-bedroom, they could pick the unit that fit their needs regardless of who moved in most recently. If it was 2-bedroom, 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 and they're all within 15% of the square footage of each other, then the landlord has to pick the tenant that moved in most recently.
Yes, because it's a comparable thing. But there's also additional protections for senior tenants
And people with permanent
disabilities or somebody who's permanently ill. If they've been there at least 5 years, they can't be evicted unless the person moving into the unit also falls under that category. So there's other
And that may
So-
make them move to the second.
Exactly, so
second
then that
refusal.
means that they go to the next person. So it is true, but there's, there's details, but
It depends.
yeah.
My units
That's
are
what-
all identical.
Yeah. So if
it's
they're
very-
comparable, then, the longer you've been there, probably the least likely that they would be able to evict you.
Oh, is the senior age for you
62.
is 62?
62.
Okay.
Yeah.
Thank you.
So for some of the at-fault evictions, the owner is required to give you a written warning prior to serving you a 3-day notice. That is not the case with non-payment of rent. So rent is due when it's due, and they can serve you a 3-day notice the next day. But with things like violating your rental agreements, say it says no pets, you get a dog, they have to give you a warning letter before they can do the 3-day notice and give you a reasonable amount of time to correct the violation.
And reasonable isn't defined anywhere, it's left open to interpretation, so we get that question a lot.
If your lease agreement says you can't have a pet and the rest of the building has pets,
So
It doesn't matter? Okay.
just like with
Just
amenities, each unit is treated as its own
Okay.
entity. There's not an equity thing about, well, they have a pet, so I get a pet.
sure.
It's,
But that's discrimination, not discrimination in the terms of race and religion and gender, but that should be amended, correct? That could be
I don't know,
amended.
but
Except for service dogs, right?
Right.
If you have a
service
dog.
animals are different, yeah.
What if you
So
had a dog?
something could be unfair but not be illegal,
What if
and
you-
so that's,
What if the no pet was under a previous owner and the new owner has pets allowed?
so
But you still
the
have-
new owner could register a pet amenity for your unit that didn't
So
previously
you
have a
can
pet
ask
amenity.
him to do it.
Right.
Yeah.
And you had a question over here?
Why don't-
Have you seen fewer unaffected evictions since April 1st?
So, we just did the annual report for, going over last year, and the Ellis numbers were, we were kind of anticipating more Ellis evictions since the state moratoriums on eviction expired, and those haven't really come through. So, we can't really, we don't really have a detailed, in-depth analysis of why or why not people have or haven't been filing Ellis Act evictions, but there really has not been a big spike in them.
Right.
So they're actually down, the last several years.
Curious because of SB 567.
Which one is that? I'm sorry. There's so many
it's
numbers.
The one that it helps with loopholes or
to close loopholes, you mean?
with, yeah.
I'll have to look it up. I know there were some things that they were trying to do, but I'm not sure that they actually passed them, but usually we know.
That doesn't.
Oh,
doesn't mean-
well, there's one the one where they have to own the property, like somebody, an owner can't just buy the property and then Ellis. Did that end up passing? I don't
No.
know, but
Well, that might have been why.
that might have been
trying to get
it.
in
Is that
so
the one
fast.
you're referring to?
It's the AB 1482, which is not, it's
Oh.
Oh, that's
separate.
different, yeah.
That's different,
That's different, that's state rent control, basically.
Yes,
Yeah.
Josh. So if there was like a dog was kind of grandfathered in, then the dog passes, and you're getting another dog, you need permission to get another dog.
So it kind of depends on the agreement. I've heard of situations where the dog was named in the lease, and then you have to get permission to replace that, and then others where it just says
One
dog,
dog, one
and
cat,
then
and it's,
you can
It's a
replace
base
it on a
amenity.
one-for-one basis as an amenity.
we also don't want people to abuse that, because then it becomes a whole issue when they litigate
I
that.
actually thought the second owner of my building who tried to evict me on getting a second dog, and he accepted rent from me for 18 months before he said, oh, I had a workman there and he told me about the second dog. I'm like, you've had workmen here every week. You know I have 2 dogs and I want it. So if you have a dog and you're paying rent and they're cashing a check after a certain amount of time, then if you have a
If
fair
they knew.
judge,
If they knew.
it's, yeah, if they knew. But I mean, after 18 months of accepting rent, the judge said, no, you knew and you accepted rent and, so.
So we talked about the written opportunity to correct that warning letter. I don't know if we mentioned the end of a lease is not a just cause for eviction. So even though most boilerplate leases say that a landlord can give 30 or 60 days notice for a tenant to vacate, that is not a just cause for eviction. And even if you sign a lease that has that provision on it, it's not an enforceable provision. So that's typically something that's more important for the newer residents, because they don't realize that and they think they got to move out because the landlord says. But that is not something that you can sign away that right.
And how you can protect yourself if your landlord says, oh, you have to move because the lease is over?
So you can tell them, no, I don't.
So there.
Yeah, if they give you an eviction notice, you have an affirmative defense against eviction because of the rent control law.
Okay.
So it's not something that we will come and represent you in court for, but it is something that is an affirmative defense against eviction
And it's
because
in the
they're
books.
not meeting one of the 10,
Right.
the 10 just causes for eviction.
So when we talked about evictions for owner occupancy, I guess I got ahead of myself, but these are some of like, the owner must be a natural person. So like a corporation can't evict for owner occupancy. They have to own a certain percentage, so 50%. And there's the specific restrictions on the selection of the unit is what we talked about. They have to pay relocation, just like they would with Ellis Act evictions. The owner has to move in within 60 days, and they have to live there for 2 years, or at least intend to live there for 2 years. And if there's an eviction for owner occupancy, that unit's rent is restricted. They don't get a market rate increase when they move out. So it's not something that can really be used to get a tenant out, and then because it wasn't, the market rate increase comes when there's a qualifying vacancy. I mentioned that at the beginning. And evicting a tenant through no fault of their own is not a qualifying vacancy. So they have to file this with us.
The incentive is you need a place to live.
Yeah.
Right?
So they have to file copies of the,
But there's no incentive. I was always worried with all the owner changes that someone was gonna like put their nephew on the sale, put him in there, get me out kind of thing. And then I found out about this first in, first out, and I got calmed down about it all. And then the fact that there's no incentive, because they can't raise the rent, is great.
So just a little matter of housekeeping, it is 7:30, this was the time that we were supposed to end. I think that we intend to kind of blast through the last parts of this and answer any questions, but we can't go super late.
Yeah, because they close at 8.
I stay because of the roommate situation, and I've stayed all this time just waiting for all the questions now.
Okay, so let us we're almost at the end, and then we'll take questions at the end.
4 more slides.
Yeah. So the Ellis Act. The Ellis Act is a state law that allows owners to withdraw from the rental housing business. It was a law that was passed in the mid-'80s. It basically allows an owner to, essentially clear out their building. They no longer want to be residential landlords, and because it's a state law, it supersedes local laws, and that's why they're able to do this. But they can't just pick and choose. They typically have to withdraw the entire property. It's a 120-day notice, so about 4 months. Tenants have to be given relocation fees as set by the city. Senior tenants, is it just seniors or disabled tenants too?
Seniors and disabled.
Yeah, they can request, I see somebody knows.
Yeah.
They can request an extension of up to a year. Oh yeah, it's right there. There you go. It's getting late. So a lot of times, if it's a senior, it's essentially, as long as they ask, it's granted. There's additional protections during the school year for these no-fault evictions too. That would apply to also the owner-occupied eviction. Basically, if you're either an educator or there's a student in the unit, they can't. Right, yeah, minors. It's minors, students. They cannot be evicted during the school year, so they have to at least postpone the eviction to the summer or whenever they're not in school. Displaced tenants who qualify, who are low income, may be given priority for affordable housing options in the city. So that's something to be aware of. That should happen. If an owner was to file this paperwork, we immediately send the tenants a packet with all this information. So this is not the kind of thing that would happen. You wouldn't know about it because they're required to file something with us. Micah and I don't deal with Ellis Act stuff too much. We have somebody in the office who does that, but she you know, if you had specific questions, you could give us a call and you could talk to her. But again, you know, we provide packets to, I believe it's within 5 days of receiving the Ellis paperwork, we get that out to the tenants, so you would be informed. Let's see. Buyout agreements. So a buyout agreement, and sometimes it's called cash for keys. It's basically a voluntary agreement to leave a unit for payment from the owner. So when an owner makes a buyout offer, the offer has to be in writing, and there's certain paperwork with the tenant's rights that they have to give the tenant when they make that offer. And although we don't regulate the buyout offers themselves, there are some basic requirements. And buyout offers, as I said, have to be in writing. Tenants do not have to accept the buyout offer. The tenant has the right to consult with an attorney or the rent control board. And even if a tenant agrees to a buyout, they have 30 days to change their mind. It doesn't become final until the 31st day. And there was a recent change to the ordinance on buyouts. And so now buyout offers actually have to be for at least the minimum offer has to be at least the same as what the city's relocation payment would be. And that is something that's new. It was just changed last month. So
how do you know what the city's minimum offers are?
That's posted on the city's website. It's basically the relocation amount. It's the housing website. I actually looked it up because I knew somebody was going to ask. It gets updated every July, but these are the permanent relocation fees, and it's based on unit size. So for a single, it's $18,250. If there's a senior, a disabled, permanently disabled person, or a minor child in the unit, it goes up to $19,050. That's for a single. For a one bedroom, it's $25,150, goes up to $26,850 for a senior, disabled, or minor child. And if it's two or more bedrooms, then it's $34,950, and it goes up to $37,250 for senior, disabled, or minor and a tenant in the unit. Like I said, those get adjusted July 1st based on inflation.
What are these numbers?
These are the average
buyouts.
Buyout agreements that have been filed. So
you've had 3 for 0 bedrooms average for that year, whatever year it is.
yeah, this was last year.
The total amount was 35, or that like one per average person?
The average amount was 35.
So we received 9 for 2 bedrooms, and they averaged $52,046.
So in my section, E, you've had 12 people, 71,000 is the average.
Mm-hmm.
Wow.
And there's a complete list of all of the buyout agreements available on our website as well.
Buyout offers, they're confidential, the agreements are confidential, but we just use aggregate information to.
But I thought I saw in the city that you do have the list for every year.
Yeah.
Who's being bought out.
So it's
a street name, but not.
It gives you.
No, I know it's not the person's name, but it gives the address and.
It's rounded to the block. So
okay, that's what it is.
It's not the actual building. If it was 1208 Lincoln, it would show up as 1200 Lincoln.
So 2 questions. When you do a buyout, how does it work as far as like, do they approach you? Do you approach them? And then when you do say yes, we'll do it, is there a set time that like, can they get you out in 30 days, or is that something you negotiate with your owner?
So it's all negotiable.
Okay.
Are you done with the slides?
Yeah, this is our last real slide.
Yeah.
Okay, just because you said questions after, so I didn't miss anything. Oh,
Yeah.
are you?
This is our last slide.
Okay,
So
so thank you so much.
we can do questions.
Can we speak about
roommates?
roommates?
See what. There's not a lot that applies in rent control to roommates, but let's see.
But you told me that.
Let's see what we can do.
Yes. So I moved into the apartment. My roommates moved out. One moved out a month after, the other moved out 2 months after, and then the landlord prevented me from
So were you a named tenant on the lease at this time?
No.
So once,
But the landlord knew that I was living there and she was okay with it.
so you were a subtenant at that point,
Yes.
approved by the landlord, but you were
Yeah.
not a tenant that was on the lease.
Yes,
So once the last named tenant vacated the unit,
yes.
Costa Hawkins would allow the landlord to reset the rents and the base housing services. So state law would let them say, okay, you can live here, this is what your rent is, and this is how many people can live here.
But she decided not to let, even though the amenities were that 3 people could
The
live.
amenities reset.
You don't have to do it.
So when there's a
It's
qualifying vacancy,
Uh-huh.
the rent and the amenities.
These
all
are just
reset.
evaluations.
It could be inside state all time.
Yeah,
The amenities and what?
and the rent reset,
So she can decide that she can only want one person living there.
correct.
And then the next person, and then.
And then when you move out, they could say a family of
people.
8 wants to move in, they could let a family of 8 move in. Okay.
I've been living in the unit for a long, long time, and in 2012, they put in a no smoking ordinance, and they even gave out, like, really grandfathered in certain units that they could smoke, right?
Sure.
And then there was a list given to all the tenants, which I have, of the units that were absolutely not smoking, okay?
Yeah.
So I live on the 3rd floor, and 2 years ago, they moved in a guy that blows all kinds of stuff, particularly weed, out on his balcony, which, you know, stinks like a skunk.
Yep.
And so I've complained for nearly 2 years to the management, and basically she said, why don't you complain to him? And this guy, you know, he screams in his apartment, he slams doors, and he's generally stoned, so it doesn't sound like somebody I really want to talk to. So I was told by the prior management that, well, I should make a complaint or file a rent reduction thing with you, and you've told me that that's not in your bailiwick. You've told me to go to
City Attorney's Office.
City Attorney's Office, which then you told me that it's really basically sending me to small claims court.
That's their
So I guess my question at this point is, anecdotally, should I go to the trouble? I mean, do you have any sense of whether people have any luck with getting that kind of thing dealt with?
I would say that what I have heard, and this is anecdotal, it's hit or miss.
Yeah.
And
that's what I kind of
you know, it's a tool to try to correct behavior, and sometimes that tool works and sometimes it doesn't. It is a fine that is potentially escalating, but you know, how much of your time and energy and effort are you willing to sink into the small claims? You know,
I'm just wondering if I let both the owner and the management company know about this issue, because I just dealt with the on-site manager, and she's basically said, it's not my problem, I don't bother.
I would say too, call the police, the non-emergency police number, because I live right on an alley. And so we have to call them all the time for the homeless, because we have a couple who have come to our alley like it's their home, and they have their breaks and they scream at 2 in the morning, and we've tried that, and they will sometimes come out.
And I think potentially also with the other behaviors that you're describing, it may potentially lead to meeting the standard of a nuisance tenant.
I want to talk to the guy that lives below it to see if it's as much fun to live under this guy as it is to live over it. The smoke rises.
Okay, thank you.
But you know, it's just it's the kind of thing that it sounds like it is, as you say, kind of hidden in terms of. But would there be any point in letting both the owner and the management company know, because they've only dealt with the on-site manager?
I think that there's value in having that discussion.
Yeah.
I think that I would go into it with kind of low expectations, honestly.
Yeah.
But it may also be something that if they were working on building a nuisance case against this person because of all of these other bad behaviors, it may be something that contributes to that and gives them extra pieces of evidence for that. I don't know.
Yeah.
You know, I don't know how that's going to play out with them. The worst thing that happens is they won't talk to you about it.
Right. And the problem is that this guy lies about it, because I get that from the on-site management. I don't smoke. He stands out on the balcony, so I mean, you know, I want to go out there and take pictures, you know.
Yeah.
But yeah, it's just you know, a smoke, a smell is not something that is gonna, I mean, it lingers for about a half hour in my apartment, but, you know, it's not something I can show you, you know, it's not like he's, you know.
Yeah, it's tricky.
Yeah.
Yeah, I was wondering about it as a nuisance, particularly if there's other tenants who you haven't spoken to yet who feel the same way, and then inform the owner, and
I mean, it's ultimately
see what
something for
happens.
the owner to enforce.
Yeah.
While, my understanding is that in the ordinance, it can't be used as a, to evict the tenant.
Smoking itself can't be used.
The smoking itself can't, but if there's language in the rental agreement
In the
that
lease,
prohibits it, and
Which I
they're
would think
violating the rental agreement,
yeah.
that would be different, but ultimately it's the owner who has that power,
Sure.
so.
Thank you.
So I think maybe we have time for one more, or we need to wrap up. But we are available to take phone calls tomorrow if you know, if anything pops up overnight that you're thinking about, or if any other questions that you didn't get answered today. You know,
Is a
Zoe wants to
nu-
call
is a
about the roommate
nuisance-
situation again.
Is a nuisance complaint something that the owner could give time to correct?
Yes.
If that's one that he could
Yes,
correct?
that's one of the ones that Measure R would
Yeah.
say you need to give a written opportunity to
For
correct.
them to correct, and then if
So-
they do, then everybody's happy.
Correct.
Uh-huh. Oh.